The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain preliminary injunctions and temporary restraining orders. So these are both forms of injunction. Let's talk about what an injunction is. An injunction is an order from a court telling a party to do or not do something. And if they violate that order, then they can be held in contempt of court. And we have an article and a video about what contempt of court entails at learn-about-law.com. So we won't go into too much detail about that here. So a preliminary injunction and a temporary restraining order are both basically placeholders between the time that a case for an injunction is filed and the time that a final order can be entered after a trial on the plaintiff's request for an injunction. So courts won't enter a permanent injunction until they've heard evidence from both sides. Witnesses have to be cross-examined. There's usually a somewhat lengthy legal case that's involved, and there's a big gap in time between the time that the case is filed and the time that the final order granting or denying the injunction will be entered by the court. So what a preliminary injunction or a temporary restraining order does is basically cover that gap between the time that the case is filed and the time that the final order can be entered in order to prevent any harm that would be caused by having the injunction not entered during that time. So they're basically temporary versions of the final order that are going to be entered. A temporary restraining order lasts for 10 days and then expires. A preliminary injunction will last basically from the time it's entered until the time that a final order on the case is entered. So the temporary restraining order is super temporary. The preliminary injunction is kind of a longer-term Band-Aid between the filing of the case and the final hearing on the merits. So often what will happen is initially, a temporary restraining order might be entered until a hearing can be held on a preliminary injunction. Then a preliminary injunction might be entered until a hearing can be held on a final, basically a full-blown trial can be held, and a final order can be entered one way or another, granting or denying the plaintiff's request for an injunction. And the reason you might do the temporary restraining order first, considering it's got a 10-day limitation, is because sometimes temporary restraining orders can be entered without notice to the other party. So both a temporary restraining order and a preliminary injunction typically require notice, but in emergency situations, the court can enter a temporary restraining order without the other party being present, and then you'll have to have a hearing within the 10-day span of the temporary restraining order in order to have a more long-term solution like a preliminary injunction entered to cover the gap until the final injunction can be entered. So that's how the time span works, and that's really the only difference between a temporary restraining order and a preliminary injunction is the duration and the exception to the notice requirement that can sometimes happen in emergency situations for a temporary restraining order. So let's talk about what it takes to get a temporary restraining order or a preliminary injunction. It's the same set of four factors that the plaintiff has the burden of proving and showing to the court in order to get one of these entered. The first factor is that they are likely to succeed on the merits of the case. So this means that they have to show the court that if the case were to go to trial, they would likely win that trial. They don't fully prove their case, but they have to show that there's a basis for strong enough evidence for the court to believe that they're likely to win once the case goes to trial. Number two is that the person seeking the injunction has to show that they would suffer irreparable harm if the injunction weren't entered. So in the span between the filing of the case and the final hearing on the merits of the case in which a final injunction will be granted or denied, the plaintiff has to show that if there's not a Band-Aid put on this, a temporary restraining order or a preliminary injunction, there's going to be harm that they suffer as a result of that lack of an injunction that can't be compensated with money damages later on. And that's hard to show. Courts like to award money damages after the fact rather than issue an injunction and have to worry about holding someone in contempt and monitoring that injunction. So, again, the plaintiff has to show irreparable harm in the event that the preliminary injunction or temporary restraining order isn't entered. Third is the balance of the equities. The plaintiff has to show that they are more likely that the harm that they would suffer if the preliminary injunction is wrongfully not granted to them would be greater than the harm that the defendant would suffer if the preliminary injunction was wrongfully granted. So basically, if the court makes a mistake on either granting or not granting the preliminary injunction or temporary restraining order, who would suffer more if the court is wrong about this? And the plaintiff has to show that the plaintiff, the person seeking the injunction, would suffer more if the injunction is not granted than the defendant would suffer if the injunction is granted wrongfully. Finally, the plaintiff has to show that it's in the public interest to grant the preliminary injunction or temporary restraining order. So this just generally, it's a very hazy concept, but it's basically, it forwards public policy, forwards the good of society, rather than something that would be against the good of society and against public interest. So those are the 4 things you need to show to get a preliminary injunction or temporary restraining order. Once you have one of those entered, then you'll have a full-blown litigation case with discovery being issued, maybe depositions, and then a final trial at the end of that. And the end product of the trial will be the court either granting or denying a final injunction. Either way, the preliminary injunction that has been in place up to that point will be dismissed and either replaced with a final injunction that's permanent, or just be dismissed and the case will also be dismissed. So if you have any questions, please leave them below our post at learn-about-law.com, and I'll try to answer them within 24 hours. Feel free to call us at 630-324-6666 to schedule a free consultation. And if you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.